Good morning. In this presentation, we will see the third section of Module 4, Constitution of India. And these are the contents: the state judiciary, the High Court, jurisdiction, and writs jurisdiction. The state judiciary. Article 214 provides that every state has a High Court operating within its territorial jurisdiction. The High Court is the highest court of the state. The Chief Justice of the High Court is appointed by the President with the consultation of the Chief Justice of the Supreme Court, and the Governor of the state and the other judges are appointed by the will of the President, Governor, and the Chief Justice of the Court. Constitution of High Court, Article 216. Every court shall consist of a Chief Justice and other judges appointed by the President of India. Besides, the President has the power to appoint additional judges for a temporary period not exceeding 2 years for the clearance of areas of work in a High Court. Also, the President has the power to appoint an acting judge when a permanent judge or of a High Court is temporarily absent or unable to perform his duties. Or the President has the power to appoint a temporarily Chief Justice. Either an acting judge or a temporary Chief Justice can be appointed by the President of India. A person to be appointed as a judge of High Court should be a citizen of India. Further, he should have held a judicial office in the territory of India for 10 years or should have been an advocate of High Court for 10 years. There is no minimum age fixed for High Court judges, and unlike in Supreme Court, there is no provision for appointment of a distinguished jurist as a judge of a High Court. A judge of High Court holds the office until he completes the age of 62 years, while in Supreme Court it is 65 years. A judge of the High Court can be removed from office only for proven misbehavior or incapacity, and only in the same manner in which a judge of the Supreme Court is removed. The President of India can remove a judge of the High Court from his office only if each House of the Parliament passes a resolution by a two-thirds majority of its members present and voting in each House requesting him to remove the judge. Next, we will see the jurisdiction of High Court. High Courts to be court of record, Article 215. Every High Court shall be a court of record and have all powers of such a court, including the power to punish for contempt of itself. That means High Court can file a case if anyone tries to contempt the High Court. Appellate jurisdiction. In civil case, an appeal can be made to the High Court against a district court decision, while in the criminal case, it extends to cases decided by the sessions and additional sessions judges if the session judge has awarded imprisonment for 7 years or more, or if the sessions judge has awarded capital punishment. In these two cases, we can take the case to the High Court. Article 227 determines that every High Court shall have the superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction, except a court formed under a law related to armed force. That means High Court is superior over all the courts and tribunal throughout the state territory, except for the court formed under a law related to the armed forces. Next, Article 228, transfer of certain cases to High Court. This is one of the jurisdiction enjoyed by the High Court. Article 228 states that if the High Court is satisfied that a case pending in a court subordinate to it involves a substantial question of law as to the interpretation of the Constitution and determination of which is necessary for the disposal of the case, it shall withdraw the case and may either dispose the case itself. That means If the High Court feels that a case pending in the subordinate court requires substantial question of law. Question of law means a question that has to be answered based on the legal principle. In such cases, High Court can take decision for the disposal of the case from its subordinate court. They can either withdraw it or they can dispose the case itself from the subordinate court. Now point B, determine the said question of law and return the case to the court from which the case has been so withdrawn together with a copy of its judgment on such question, and the said court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. That means after determining the question of law, the case will be returned to the subordinate court from where it has been withdrawn with a copy of the judgment of the High Court on that question. Accordingly, the subordinate court shall dispose the case after accepting the judgment from the High Court. That is what is written in Article 228. Next is writ jurisdiction, Article 226. Notwithstanding anything in Article 32, every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories directions, orders or writs, including writs in nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them, for the enforcement of any of the rights conferred by Part 3 and for any other purpose. That means whatever there is in Article 32, High Court has a right to exercise power throughout the state territory. High Court can issue directions or orders or writs to any person or authority in appropriate cases for the enforcement of right conferred by Part 3. That is Article 226. And that's the end of Part 3. Thank you.